Hi guys. Well, the countdown has officially begun for landlords across Wales. If you own a rental property in Newport or anywhere in South Wales, there's an important legal deadline you need to know about. And missing it could cost you money and potentially affect your ability to regain possession of your property in the future. The deadline is the 14th of June 2026. And in this video, I'm going to explain exactly what's changing, why it matters, and the simple steps you need to take to make sure you're fully compliant. As you've probably heard, the Welsh Government has incorporated the new anti-discrimination rules introduced through the renters' rights legislation into Welsh housing law. The key change is that landlords can no longer impose blanket bans on tenants simply because they have children or they are claiming benefits. Now, most landlords understand that the law has changed, but here's the important part. It's not enough just to know about the new rules. You must formally update your occupation contract documentation. The new provisions are being added to the Renting Homes Wales Act 2016 as two new fundamental terms, Section 54A and 54B. Now, in Welsh housing law, fundamental terms are the legal foundations of the occupation contract. They must be included exactly as prescribed by legislation. And whenever the Welsh Government changes a fundamental term, landlords have a legal obligation to notify their contract holders through a formal written process. The commencement date for these changes is the 1st of June 2026. And landlords have just 14 days to issue the required documentation. This means every existing occupation contract in Wales must be updated by midnight on the 14th of June 2026. So this isn't one of those deadlines that's simply nice to have. There are real consequences. Firstly, contract holders can potentially seek compensation through the courts. In some cases, that compensation can be worth up to 2 months' rent. Secondly, and perhaps even more importantly, for many landlords, you may be prevented from serving a no fault possession notice while your paperwork remains non compliant. So this is definitely something you don't want sitting at the bottom of your to-do list. So how do you actually update your contracts? The Welsh Government allows two methods. Method A, written statement of variation. Now, Method A is what most landlords and professional letting agents will choose. This involves serving a written statement of variation. Think of it as a legal addendum to the existing contract. Rather than reissuing an entire 40-page occupation contract, you issue a short document that explains the contract is being varied, the new fundamental terms being added, exactly where those terms fit into the existing agreement. The Welsh Assembly government has even provided standard wording for this process. It's simple, efficient, and creates a clear audit trail. Now, there's method B, and this second option is to issue an entirely revised written statement of the occupation contract. This means updating the full document, inserting the new fundamental terms, and then issuing the complete revised contract to your contract holders. It's perfectly valid, but it does involve significantly more paperwork, more printing, and more opportunity for mistakes. That's why most professional agents are expected, and landlords, of course, are expected to use the variation notice route for existing contracts. Now, let's walk through the process. Step one is identify your affected tenancies. So, start by reviewing your portfolio. Any private standard occupation contract that's active on the 1st of June 2026 needs updating. That includes fixed term contracts, periodic contracts, individual room contracts within HMOs. One important exception is new contracts created on or after the 1st of June should already contain the new terms, so they don't require a separate variation notice. Step 2. From the 1st of June, the Welsh Assembly will make the official variation wording available through gov.wales. Make sure you're using the correct wording for 54A or section 54A, the right for children to live or visit the dwelling. Section 54B, the right to claim benefits. Using unofficial wording could create problems later on. And step 3, prepare the documents. Complete the variation notice carefully. Check contract holder names, property addresses and dates, contract references. Everything should match your original written statement exactly. Even a small error can create disputes about validity. And step 4, serve the notice. You cannot serve the notice before the 1st of June, and you must serve it by the 14th of June. If you're sending electronically, make sure your occupation contract specifically allows service by email. If it doesn't, use one of the approved alternative methods. And step 5, keep proof of service. This is one area landlords often overlook. Keep evidence that the notice was delivered. For example, signed acknowledgements, postal tracking records, email read receipts. Remember, if there's ever a dispute, the burden of proof sits with the landlord, not with the tenant. Now, before you send anything, ask yourself these 4 questions. Have I served every named contract holder individually? Does the document contain exact statutory wording? Have I clearly identified where the new terms fit into the existing contract? And have I stored proof of delivery safely? If the answer is yes to all 4, you're in good shape. The reality is that Welsh housing legislation is changing rapidly between compliance requirements, maintenance issues, rent collection, licensing obligations, and everything else involved in managing a property portfolio. Many landlords simply don't have the time to stay on top of every legislative update. And unfortunately, one missed deadline or one incorrectly drafted notice can create significant problems later on. At Bluestone, we've already prepared a compliant variation packages for our managed landlords. Our team will ensure the notices are drafted correctly, served within the legal deadline, and fully documented so that you have a complete compliance record. If you'd like us to review your existing paperwork, carry out a compliance health check, or simply take the pressure off managing your rental properties, we'd be delighted to help. The 14th of June deadline is approaching quickly. Don't leave your compliance to chance. Contact Bluestone estate and letting agents today, and let's make sure your South Wales property portfolio stays fully compliant, protected, and profitable. Thank you for watching, and we'll see you in the next video.